I'm going to do a really quick run through this panel because it is a pretty remarkable panel. Just to quickly introduce myself, I'm Katherine Courtney. I'm the chair of the Global Network on Sustainability in Space, the former UK space regulator, as the former CEO of the UK Space Agency. But in respect of this topic, for me, more importantly, I'm not a subject matter expert. I'm more really just a concerned citizen and a parent of 3 small children. I'm delighted to be joined by Chris Newman, Professor of Space Law and Policy from Northumbria University, Brian Weeden, Director of Program Planning for the Secure World Foundation, and Niklas Hedman, the Chief of Policy and Legal Affairs for the UN Office of Outer Space Affairs, and Stefano Gallozzi from the Italian National Institute of Astrophysics. So without further ado, let me go straight to the subject matter experts. Chris, could you please give the listeners a very brief introduction to relevant aspects of current space law?
Absolutely. Thank you so much, Catherine. Thank you, everybody. It's a real genuine honor to be amongst such distinguished people. Very humbling for me to be amongst such distinguished experts. And what I'm going to do is talk about the governance of outer space. We tend to talk about space law, but I prefer to talk about space governance because the law is actually only a part of it. So let's start right at the top table, if you like, of space law, the international treaty commitment of states. Now, as Andy said right at the start, these are relatively, compared to space activity, these are relatively old instruments. We have the Outer Space Treaty of 1967, which we've already talked about. We've already talked about how that imposes obligations on nation states. It imposes freedom to explore, freedom to use, freedom to scientifically investigate, but it puts limitations on them. And it imposes what I call the liability or the accountability triangle. So you have Article 6, international responsibility for space activity lies with nation states. So it's nation states who are internationally responsible. Then we have this notion of launching states. States who actually launch stuff up there, they're internationally liable for the damage caused by their space objects to other state parties. And then we have jurisdiction and control granted where there's registration of a space object. So that's, if you like, the top tier. Then underneath that, as a result of these obligations, we then have national space legislation, usually where the regulation sits, usually where regulators live and where they authorize space missions. And then we have another dimension to this, the non-treaty agreements, the things that aren't necessarily binding law, but that are very, going to be persuasive, and they're going to influence national regulators. So we think about the UN debris mitigation guidelines as the sort of the premier amongst them, but we've got the ISO standards, we've got industry best practice. Now, just to very quickly summarize, what we've got here is a collision almost. We've got a horizontal international legal system. Yeah, states can't force states to do anything they don't want to. In a vertical system, where a national system where we have the government and we have penal institutions and we have law enforcement, they can force me to do something. On an international level, that enforcement becomes really difficult. So I really like Mariba's statement about off-the-shelf science. Well, off-the-shelf law, it's very tempting to think we can get a law that can cover everything and that can deal with everything. But as Niklas is going to tell you, international treaty negotiations, they take a long time. As Brian's going to tell you, the geopolitics of this is immensely complex. It's not just a question of a law that's going to enforce, what we want. We're going to have to do a lot of public pressure on this. We're going to have to get to our elected representatives. That's where the pressure points are. The law, that'll come later.
Thanks, Chris. Well, you've set that up perfectly to hand the virtual mic to Brian. Brian, what is wrong with the current state of affairs? Why don't today's space governance mechanisms work?
Well, thank you, Katherine, for inviting me. And just to build on what Chris was talking about, one of the key challenges is sort of how this stuff is operationalized at the national level. Just for example, here in the United States, which is licensing some, but not all of these large constellations, the regulators, the institutions that are responsible for licensing things are not set up to deal with a topic such as light pollution. And it's it's not obvious that that is something that is required for them to do. The primary regulator, the Federal Communications Commission, is set up to license radio frequency spectrum use. And that is what they're good at. That's what their expertise at. And in fact, there has been an international discussion for the last several years coordinating the RF spectrum aspects of these large constellations. But there is not a similar mechanism or institutions or existing process to deal with the light pollution aspect of it. So what we're dealing with here is a situation where there's just not the pathways, the capacity for governments to even really deal with this aspect of light pollution, and it's they don't have time for it, right? Because these constellations are already being launched, already putting up, and as Chris mentioned, not only does the international treaties take a long time, but so does building governmental capacity to regulate. That takes a long time as well.
I'll just ask you a quick follow-up on that, Brian. So what I've observed around the world is that some signatories to the OSA agreement haven't managed to introduce any national level space law. And where there are regulators, and at the minute, for instance, the US, the UK, we're in the process of changing regulatory authorities and shifting it to new institutions who may or may not have the funding and skills to exercise those duties. Could you talk a little bit about that? It seems to be that you've reflected on that in your remarks.
Yeah, so that's the other big challenge here. So Chris mentioned this concept of launching states and under the Article 6 jurisdiction. There can be multiple countries that are potentially liable and thus might have to have some sort of oversight role over these companies or these activities. And then it's inherent for each of those countries to put in place a national regulatory regime. And that's difficult to do. Even advanced countries like the United States, as I just said, don't have what I would call a very broad regime that covers all of these new and emerging things, particularly because the commercial industry is coming up with new ways and to use space that very quickly. And so even large countries like the US and the UK, or say advanced countries, are struggling to deal with that. So this gets back to this question of, even if there is a new international treaty, how does that get operationalized through the national implementation? That itself is going to take a very long time, and something that lots of countries are going to have to grapple with. Just a very quick point to finish on. One of these large constellations, AST Space Mobile, is the primary regulator is actually Papua New Guinea. That is who has the spectrum license for them. And that's a country that now has to put in place some sort of regulatory regime to keep a track of all these things.
Now I'm going to throw a question over to first to Niklas and then to Stefano to get the astronomer's perspective on this. Stefano, question I have is, what needs to be done? What can we do? How can we fix the governance in order to preserve space for future generations? Niklas.
Yeah, thank you, Catherine. Can you hear me well? Yeah, good, excellent. Well, the question is, what would we like to do and what can we do, you see? And this is really the crux of the matter and the problem that we have seen in this webinar so far. If we look at the space law, international space law as a whole, with the treaties, with the resolutions, the set of principles, guidelines, everything, it's dealing predominantly with activities in outer space. So the space law, international space law, is not really dealing with astronomy from Earth. However, astronomical observations from installations in outer space or in the future from celestial bodies would be covered naturally, but not from Earth. And this is really leading into the complexity of what we are discussing here and the frustration. Now, Chris said something very interesting, giving a perspective of the history of space law making. I would just like to picture this. Look at this as a time scale. 20 years in making the treaties. The 5 UN treaties on outer space took more or less 20 years. From 1963 with the declaration to the Moon Agreement 1979. And then 20 years of dealing with principles that are non-legally binding, but nevertheless, in a little way, closer to treaty lawmaking, but they are nevertheless non-legally binding. 20 years. And after that came a period of 20 years in looking into implementation of the rights and obligations of the treaty. So there we have all those guidelines, space debris mitigation guidelines, and ending in 2019 with the long-term sustainability guidelines. Definitely non-legally binding. The question is, what next? And I just want to make a point here that we heard earlier, and also from IAU perspective, that it was presented only a few weeks ago to our scientific and technical subcommittee, a proposal for recommendations generated by IAU, several states, and also the Office for Outer Space Affairs in a cooperation. There was no consensus. So now there is a mandate for the Office for Outer Space Affairs to work with IAU, work with the states that are interested, in particular Spain, because we are planning an activity, a workshop in October, to form a basis, a proposed basis for how dark and quiet skies could be integrated into the agenda of the Scientific and Technical Subcommittee in 2022, hopefully. So it's still, you know, it's just part of diplomacy, part of multilateralism, but it could be, I say, the first time that astronomy and the whole issue, the whole spectrum of dark and quiet skies could enter into the formal agenda of this unique intergovernmental body. So let's see.
Well, that's heartening to hear. Stefano.
First of all, I have to say that I'm an astronomer, I'm not a lawyer, and I totally agree with other speakers and for whatever is related to the international treaties and so on. The point here is not what we would like to do, just because we are from our small sides, what we can do. Just I can explain my experience because from the astronomer side, I personally approached to the problem of the mega constellations of satellites because I am also very active in environmental issues. So just because I have been president of an Italian environmental protection committee for years, and so I collected a series of intervention strategies which, in my opinion, when they are correctly implemented, they can manage to block or at least slow down any speculative project. So even when we can say that in our experience there is a very great interest in companies, corporations, and private investments, even in these cases, we can do something. In particular, in January 2020, I was the promoter of a petition called Appeal by Astronomers. This is just an action to raise the awareness from the astronomical community, because if even I was an astronomer, this kind of discussion was done only at political side of the astronomical community. So it is important to understand that this action of awareness has collected about more than 2,000 signatures from colleagues who supported from more than 50 countries all around the world. But what we express here is the fact that we don't talk of mitigation procedure to minimize problem and threats on astronomical observation. What we would like to obtain is just to avoid the problems, because we are not intended to collaborate or coordinate efforts in order to minimize some problems, but we are working from 1,000 years on these kinds of professions, so we would like to continue to do so. In particular, we also take account on legal issues, because the political side is not on our effort, and in particular we used the LT11 Trust Initiative, which is a spontaneous initiative of a legal international network of lawyers aimed by noble environment protection purpose. And they filed out a petition for a review to the FCC, the Federal Communication Commission, for expedited rulemaking and an opposition on the FCC approval of elevation modification. This review is pending to the FCC, but the next step is just to sue in court, even to the International Court of Justice, because if you take care to make the pronunciation like Viasat on a federal court of justice, a federal US Court of Justice, this does not resolve problems from Chinese, from Russian, from Korean, and other satellite constellations. So the only way to push the international United Nations, COPOS, UNUSA, and another international institution to rulemaking on this kind of problem, just to organize better everything related to the satellites in low Earth orbit. We just have to make a pressure on International Court of Justice, which could even declare the Federal Commission and Agency, National Federal Commission and Agency authorization as to be considered unlawful. This could be a very impact action, in particular because we need just to realize this, we need to be legitimated under the International Court of Justice. So we create a foundation. This foundation called SAS Foundation, where SAS means Safeguarding the Astronomical Sky Foundation, is an international ONG under the Italian law, which was born just to have the legal legitimation on this possible legal action. So I think that our experience can help individuals from their side to join together to create a critical mass, we can say a fight of dissent, to push the politics and institution in the desired way. And maybe this could be the right way to express our dissent on something which is a threat for all the mankind.
Very, very, very interesting ideas.
You have good points, but you have to push this via your own government, you see. This is the reality we live in. This is the society we have. Rule makings are done by governments internationally and then being implemented at the national level. So you have to influence your government. Then your government could potentially influence the intergovernmental diplomacy. How
do we encourage a race to the top then between licensing nations? Because we do see this this license hopping behavior, you know, on the part of satellite operators. If they find one regulator is asking too many questions, they can always go and get a flag of convenience from somewhere else. Brian?
So, you know, that is a possibility, but it may not be that dire because there's something else called market access rules. So, for example, all these companies, if they want to sell these services in the United States, they must get a license from the FCC. So those countries that have big markets where these companies want to services, they do have some power. So maybe not the Chinese constellation, but probably pretty much every other one is going to have to get or want a license from the FCC. So there are probably same thing in Europe as well, from, you know, some of the several major European countries. So that does provide the opportunity for a couple of countries to have a role here, but then the problem still becomes convincing those countries to do something and implement something.
some great questions. So lots of concern about how much time it's going to take to legalise this. Brian Eno saying that the law is just not going to be fast enough here. He's saying, do we need Extinction Rebellion to set up a space department? Chris, you've talked before about a Greenpeace for space. Is that realistic? Do we need people to take this sort of action?
Yeah, I think we do, because I think absolutely, as Brian said, as Hugh said, there isn't the time to go through a lengthy legal procedure. I see in the chat a number of discussions about, can we sue them for this? Can we, go and get the government to do this? The law isn't going to give you the answer that you want here. The law will come from the public pressure, from an awareness that this is something important. It goes back to what Timmy Abbey was saying. We have to win this as an argument. We have to win this as an argument, and then that becomes something that we can use to influence governments. Because like Nicholas said, it's going to be the governments that are going to be doing this. They're going to be making the legislation here. That are going to be making international agreements on this. I've talked with numbers of colleagues. I see Thomas Cheney's in the participants list as well. And we've talked about this before, how Friends of Space or Greenpeace could be, a way of recognizing this as a real sort of important thing that gets it up the politicians' list, because there are so many things right now on the politicians' lists. COVID, the economic recovery from COVID. We've got to compete with that type of discussion. And we can do that because, we're all here because of the magic of space, because we've been infused with that magic. We've got to try and get that message.
The FCC's already approved Starlink to launch 12,000 of these things. Is there any way we can suspend those launches? This is a question from Ian Smith. Can we pause this? Can we put a moratorium on new space launch whilst treaties and laws are being negotiated? Is there any way to pause what's already in motion?
There's a way to pause, one or two, but don't forget, China are doing it, Russia are doing it. There are going to be other countries doing this as well. We need a more sustainable approach. We need an approach that's going to be recognized, across the world. One jurisdiction can do something, but everybody together, that's the way we've got to approach this.
And just quickly to add on to that, that is initial approval given by the FCC, pending SpaceX providing additional documentation on how they're going to do their post-mission disposal and the debris mitigation. There's also the bringing into use aspect of it. So they are required to have a certain percent of the constellation up by a certain date in order to retain their spectrum access rights.
And there's also a wonderful new article on Scientific America today that people might look at, reporting about a court case that's just going to
May I ask one point in this regard very quickly, because this is an interesting discussion also feeding into what we have heard earlier in the webinar. I don't want to put anyone down, but there won't be any new legally binding instruments in the foreseeable future. Forget it. There is no consensus among the major spacefaring nations in that regard. So it's just to forget. And then we have to work on what are the tools we can apply to make the best of the situation. And we cannot forget that political pressure is also quite powerful. And in developing non-legally binding instruments, I'm a lawyer myself. I love treaty law, of course I do. But non-legally binding instruments in the form of guidelines might be the best we can achieve. And it has to come with political buy-in from governments. And don't underestimate also what is being done by other organizations closely connected to the United Nations. For instance, COSPAR, the Panel on Planetary Protection, which is operational and really is the, per definition, hub of buy-in from the major spacefaring nations on planetary protection requirements for their planetary missions. And that is done by a non-governmental organization. And it's a system that works. So there is hope. And what I said earlier, that now we will see next year in the Scientific and Technical Subcommittee if we can get a consensus on moving forward on dark and quiet skies. Because if we get that into the agenda of this intergovernmental body, then we have an impetus to continue discussing all those topics that we have addressed here today.
It was, I know there's been a lot of commentary, but it was very welcome to see the G7 declaration on Sunday on space sustainability. We have the opportunity at COP26 and the G20, et cetera, to keep putting that on world leaders' agenda. I think probably nobody would have predicted 10 years ago that China would be in a race to the top on environmental concerns. And I think we've seen some amazing results from public pressure from our Sir David Attenborough's, making it visible, making these problems visible, from Greta Thunberg. And I do believe that actually raising public awareness through events like this one, thank you, Andy, for inviting us all to participate, is a critical way of, helping the public to visualize the issues and to get more involved.